The Texas court system comprises courts on 5 levels, from the Supreme Court and Court of Criminal Appeals at the uppermost level to the municipal and justice of the peace courts on the lowest level. We will begin to see the courts individually. The municipal courts, their function. The term municipal court means different things in different states. The municipal courts of Texas are very different and have much more limited jurisdiction than the municipal courts of, for example, California and Minnesota. Although Texas municipal courts have the most limited jurisdiction of any trial courts within the Texas judicial system, they handle far more cases than any other Texas court. Municipal courts are especially important because the public has more contact with them than with any other courts in either the state or the federal system. The primary function of municipal courts is to try minor criminal offenses. Because of the heavy volume of cases and because the cases tried are of a less serious nature, proceedings are generally less formal than in the higher Texas trial courts. To expedite proceedings, court clerks and bailiffs often participate in the plea-taking process. In recent years, criticism has been leveled at the lack of formality in some of the municipal courts. Although cases are expedited and defendants are made to feel more comfortable, sometimes important constitutional rights, such as the right to be fully notified of the charges, are hampered. Critics also point to the lack of respect for the court and the confusion concerning general courtroom procedures created by informal processes. Fortunately, the use of computers and better selection procedures and training programs for judges and court personnel have vastly improved the quality of justice in many municipal courts. Jurisdiction. Class C misdemeanors. Criminal jurisdiction is limited to Class C misdemeanors in a municipal court and violations of city ordinances. Class C misdemeanors are minor criminal offenses for which the maximum punishment is a fine of $500, exclusive of penalty, interest, and court costs. A Class C misdemeanor does not include jail time, but punishment may include revocation of privileges, such as a driver's license or permit. A Class C misdemeanor is the least serious criminal offense under Texas law. The offense of driving a motor vehicle through a red light on a public roadway is an example of a Class C misdemeanor. Other common Class C misdemeanors include driving without a license, disorderly conduct, simple assault, theft under $20, and public intoxication. Municipal court jurisdiction over Class C misdemeanors is not exclusive. Justice of the peace courts have jurisdiction over most Class C misdemeanors that arise within the county, while municipal courts have jurisdiction over Class C misdemeanors that arise within the city. Theoretically, a traffic violator who runs a red light in Dallas could be tried either in the Dallas Municipal Court or in a Justice of the Peace Court within Dallas County. In actual practice, however, most Class C misdemeanors in urban areas are tried in municipal court. Justice of the Peace Courts try those Class C misdemeanors occurring in unincorporated areas of the county or occurring on state-controlled roads and highways. And the legal system is quite complex in Texas, where you have the Texas Rules of Appellate Procedure, you have the Texas Government Code, and you have the Texas Rules of Civil Procedure, and then the Texas Judicial Qualification Commission that has to do with disciplining judges. So you must also be aware of the Code of Judicial Conduct. And then, of course, it is all within the scope of Vernon's statutes. The municipal ordinances. Municipal courts have exclusive jurisdiction over violations of municipal penal ordinances. A city has the power to enact laws within its jurisdiction. These laws, when passed by a majority of the governing body, the city council or city commission, are called ordinances. Some of these ordinances are penal in nature. That is, they carry a punishment in the form of a fine for their violation. For example, an ordinance that requires homeowners to maintain covers on their trash receptacles or face a fine up to $200 is a penal ordinance. Violations of this ordinance would be tried in the municipal court of the enacting city. Municipal ordinances are valid only within the city limits of the enacting municipality. Thus, municipal courts' geographical jurisdiction over municipal ordinances, like jurisdiction over Class C misdemeanors, is within the city's boundaries. Nuisances within 5,000 feet of the city are an exception to this rule. If someone violates a city ordinance prohibiting the sale of fireworks within 5,000 feet of the city limits, the offender can be tried in that city. Permits and licenses. Municipal courts have jurisdiction to suspend or revoke certain licenses or permits. A license or a permit is a conditional grant or a right, such as the right to sell alcohol beverages at a certain location or the right to drive. Failure to meet these conditions of the grant triggers a suspension hearing. Of course, when it comes to the licenses, the so-called driver's licenses, truly no real American is required to have one, except as become by contractual endeavor to get under this driver's license in order to collect monies. The most common of these are hearings to suspend a driver's license, which really would belong to a commercial driver driving under a corporation for corporation purposes. The jurisdiction, of course, is shared by Justice of the Peace courts. Appeals. Convictions in municipal courts may be appealed, as in any other court. A few municipalities with municipal courts of record, a court in which a court record transcribes the proceedings, also have a municipal appeals court, and the trend is overgrowing. Most appeals from municipal court are heard in county count in a trial de novo, which means that the court tries the case as if it had filed originally in that court. Lacking a transcript of the trial at the municipal level, parties must literally start over at the court level if they do not like the results of the municipal court. One criticism of this process is that trial de novo encourages appeals to county courts and causes huge case backlogs. Processing these backlogs often requires dismissals and plea bargaining based on certain experience rather than on merits of the case. In 2003, the Texas legislature enacted the Uniform Municipal Courts of Record Act, which authorizes any municipality to create one or more municipal courts of record. Texas Government Code, Annual Section 30.00001. The Act provides rules for establishment and ongoing operation of these courts, and expressly provides that a municipal court of record has no terms and may sit for any time for the transaction of business of the court. Texas Government Code Annual Section 30.00003. The municipal courts of record have jurisdiction over the same matters as the municipal courts. Appeals from a conviction must be made within 10 days from the entry of judgment. An alternative to the 10-day rule arises in cases when the defendant waives the right to a jury trial and pleads either nolo contendere or guilty before the date scheduled for appearance in court. In such cases, the defendant is given 30 days to appeal. An appeal is usually made by posting an appeal bond. An appeal bond is a promise by the defendant to appear at the trial of the case in county court or forfeit the amount of the bond. Most appeal bonds are made by obtaining the signature of two sureties along with the signature of the principal, the person found guilty at trial. Alternate methods are posting cash or cashier's check in the amount of the bond. If the defendant is successful in county court and is found not guilty, the defendant's conviction in municipal court is voided and no record is kept of the conviction. A conviction in county court may not be appealed further unless the amount of the fine exceeds $100, exclusive of court costs, or involves a violation of constitutional rights. If the fine exceeds $100, the defendant may appeal a conviction to the Court of Appeals. If a constitutional question is involved, the convicted person may appeal from that court to the United States Supreme Court. Procedure. Please. In the municipal court cases, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The defendant has the right to be notified of the charges which are set forth in a criminal complaint, the right to be represented by an attorney, and the right to demand a jury trial. A defendant may plead guilty, not guilty, or nolo contendere, which means I'm not contending, but the truth is he can also object to the entire proceedings and simply state that he does not plead in a court of contract. Juries. Juries in municipal court are composed of 6 persons who are residents of the municipality for which the court is established. The verdict must be unanimous for a conviction. Usually when a jury hears a case, it is the trier of fact and the judge the interpreter of law. At least it is in statute rules. But the reality is that the original juries under the common law are both trier of fact and interpreter of law, and their judgment stands final, and no judge can turn that judgment. But in municipal court there is a peculiarity. The jury is the trier of the facts and the interpreter of law, which is supposed to be common law, although in practice the judge usually instructs the jury regarding the law, which is really an overstepping of authority by this judge. Jury trials are usually set on separate dockets and tried on a special setting. Preliminary hearings are set by the court to dispose of motions prior to trial. Since the amendment of the Speedy Trial Act in 1979, all Class C misdemeanors must be tried within 60 days from either the date that a complaint is filed in a court against the defendant or the date of the arrest, whichever is earlier. In many Class C misdemeanor cases, such as traffic violation, no arrest is made unless good cause for the delay is shown. Failure of the municipal court to try cases within this time will result in a dismissal. Judges. Municipal judges must be lawyers with 2 or 5 years' experience in the practice of law or in the judiciary. Only a handful of municipal judges are elected. The vast majority are appointed by the governing body of the city that they serve. The mayor of a general law city serves as municipal judge unless the city council provides for the election or appointment of another one. Municipal judges preside over the presentation and trial of minor criminal cases. If there is no jury, the judge must first determine the facts and then apply the law to the facts to determine whether the defendant is guilty. If a jury is impaneled, the judge, as previously stated, often instructs the jury as to the law. Because the tremendous volume of cases a municipal judge hears, he or she is an important representative of the state of Texas judicial system. Far more people come into contact with the municipal court than in any other Texas court. In addition to the usual function of presiding over cases, municipal judges have other responsibilities as magistrates, which is really their real position. All Texas judges are magistrates, but the bulk of the magistrates' function fall upon justices of the peace, magistrates appointed by district courts, generally in large metropolitan counties, and the municipal court judges. Magistrates conduct arraignments, set bail, and issue search and arrest warrants, including those matters too serious to be tried in a municipal court. All municipal court judges have the power to enforce judgments and orders and to take judicial action necessary to guarantee that trials proceed in accordance with the law. They also have the power to issue writs, subpoenas, and other orders to require that necessary evidence be produced to guarantee the orderly proceedings of cases and to compel the attendance of witnesses. Supporting personnel, agencies, and process. The staff of the municipal court includes a municipal court clerk, the bailiff, the warrant officer, and the prosecutor. All of these officers are appointed by either the city council or the chief executive officer of the city. They are subject to removal at the discretion of the appointing authority. The municipal court clerk's base function is to serve as custodian of the official records and documents of the court and to assist in docketing of the cases. The clerk is responsible for scheduling cases for trial and a docket sheet that lists cases scheduled for trial at a particular day and time. The docket sheet usually contains the number of the case, the name of the defendant, an indication of whether the defendant is represented by an attorney, the name of the attorney, a description of the offense, a name of the police officer who will testify. Another document that the clerk prepares in the process is the complaint. The complaint describes the offense that the defendant is accused of committing. It contains the defendant's name, the date of the alleged offense, and the location of the offense. It states what the defendant allegedly did in sufficient detail to correspond to the penal statute or ordinance that the defendant is accused of violating. Failure of the complaint to spell the defendant's name accurately, to describe the location of the offense, or to recite a particular violation contained in the penal statute or ordinance may cause the charge to be dismissed. During the trial, the prosecution must offer evidence to prove the essential facts of the complaint. The complaint should be distinguished from the criminal citation, which is the citation or notice that a police officer gives an offender. A citation is a notification that the officer has charged the person named therein with a minor offense. When the person signs the citation, he or she makes promise either to plead guilty or pay a fine or to appear at the trial of the charge. Another important record that the clerk keeps track of is the judgment. Although municipal court judges are not required to file findings of fact and conclusions of law, they must render a judgment in every case. Usually this is a short notation of the type of case, the finding of guilty, not guilty, or nolo contendere, and the setting of a fine. The clerk is in charge of maintaining accurate and up-to-date records of all municipal court judgments. The bailiff is a peace officer who keeps order in the court. A municipal court bailiff is also charged with protecting the judge and witnesses and with serving the court documents. The most common served court document is an arrest warrant, which usually must be delivered personally to the individual named in the warrant. Sometimes peace officers, called warrant officers or city marshals, serve warrants instead of bailiffs. The person who represents the state in criminal proceedings in municipal court is called the prosecutor. The prosecutor presents evidence on behalf of the state in all Class C misdemeanor cases tried in these courts. Although the prosecutor is usually a city attorney or an assistant city attorney, he or she actually represents the state rather than the city in the proceedings. The prosecutor plays a significant role in scheduling cases, in disposing of defense attorneys' motions, and in plea bargaining. Vital to the function of the municipal court is the city's police department. Most criminal complaints in these courts are sworn to by a police officer. Police officers are the key witnesses for the state in most trials in municipal court. Although the police department has many other functions, it is the primary investigative and enforcing arm of the court. Other departments of city government that may institute criminal complaints are the fire, building, inspection, health, and consumer affairs departments. Finally, the Municipal Court Fines Bureau is the administrative department set up to collect all fines assessed by the municipal courts. The vast majority of municipal fines are paid with checks or money orders sent by mail. A growing number of municipalities take credit card payments, including some that can process fine payments online. Among the Bureau's other functions are keeping records on delinquent citations and bonds, processing appeal and cash bonds, and keeping records of defendants' criminal convictions in cooperation with other law enforcement agencies, especially the federal government, which is completely illegal. Justice of the Peace Courts. Function. Justice of the peace courts have changed dramatically since King Edward of England appointed the first justices of the peace in 1360. They were originally called just merely judges of peace. These early English courts had broad jurisdiction, including the trials of felons and trespassers. Prior to the American Revolution, justice of the peace were officials who exercised great authority. Since the first justice of the peace court was treated under the Texas Constitution in 1836, the power of the court has been considered reduced. During the days of the early Texas frontier, justices such as Judge Roy Bean ruled supreme as the only legal authority in vast areas of the state. In fact, Judge Roy Bean was a bigoted murderer. He said it was perfectly legal to rape and kill Indians, Mexicans, and Chinese. So one can imagine the horror of having such a man as judge in the land. Since the very stability of the frontier depended on their quality, these justices of the peace were chosen for their ability to enforce law, and not so much for their integrity. As Texas population shifted from rural areas to urban centers, the law became more important than the men who were called upon to administer the law. Justice court jurisdiction was eventually reduced to trials of minor offenses, and justices were forced to share their criminal jurisdiction with newly created municipal courts. Today, many legal scholars consider the Justice of the Peace Court an anachronism, with judges who are often untrained in the law presiding over many complex legal problems, and it becomes nothing but a political arena. Judicial reform has helped improve the quality of the justices in these courts. New laws requiring mandatory training for judges, the raising of the monetary amount of the civil jurisdiction of the courts, and the growing importance of the small claims function of these courts are attracting a growing number of qualified lawyers to seek this office. Jurisdiction. As created by the Texas Constitution, Justice of the Peace Courts have both criminal and civil jurisdiction. Like municipal courts, justice courts are trial courts without appellate jurisdiction. Geographical jurisdiction. Justice of the Peace Courts have jurisdiction within the boundaries of the precincts in which they sit. Precincts are geographical areas within a county, with boundaries determined by population and by convenience to prospective litigants. Each Texas county within a population of 30,000 or more is divided into at least 4, but no more than 8 precincts. Each precinct contains at least one justice of the peace court. Large, sparsely populated counties may have only 1 or 2 justices of the peace, while densely populated counties may have several justices sitting in each of their precincts. Criminal jurisdiction. Justice courts have concurrent jurisdiction with the municipal courts over Class C misdemeanors, punishable by a fine only, irrespective of the amount. Most trials of Class C misdemeanors occur in municipal rather than justice courts. Justices usually preside over trials of Class C misdemeanor violations that occur in unincorporated portions of the county, on state highways, or on state town toll roads, where they have exclusive jurisdiction. Civil jurisdiction. The Texas Constitution gives to justice courts exclusive jurisdiction over civil cases where the amount in controversy does not exceed $5,000, exclusive of interest and court costs. Justice of the peace courts cannot issue injunctions. Regardless of the amount in controversy, justice of peace courts do not have jurisdiction over lawsuits involving the following matters: a suit on behalf of the state to recover a penalty, forfeiture, or escheat, a suit for divorce, a suit to recover damages for slander or defamation of character, a suit for trial of title to land, a suit for the enforcement of a lien on land. District courts have jurisdiction over these cases. Small claims court. Justices of the peace are authorized to sit as judges of small claims court. A small claim is a recovery of money where the amount involved, exclusive of court costs and interest, does not exceed $5,000. No claim may be brought in this court, however, if the party suing is the assignee of a claim and is in the business of lending money or is a collection agency. The reason is because there cannot be any third-party pleadings. The purpose of the small claims court is to provide a simple and economical forum for the average person who wishes to litigate a small claim. Actions begin in small claims court through the filing of a simple petition. A plaintiff may represent himself or herself, thus saving the cost of a lawyer. In making a decision to hire a lawyer, a claimant would need to consider the complexity of the matter and the amount sought to be recovered. A small claims petition includes the defendant's name and address, the dates of the significant events, the amount of monetary damage claimed, and a concise statement of the nature of the claim. Exclusive jurisdiction. Justice courts have exclusive jurisdiction over forcible entry and detainer suits, often referred to as eviction suits. These suits involve the summary court proceeding that results in restoring possession of the leased premise to the landowner. Justice of the peace courts have jurisdiction over all forcible entry and detainer suits except those involving disputes over the title to real property. They also have exclusive jurisdiction over suits to foreclosure mortgages and enforce liens on personal property where the amount in controversy does not exceed $5,000. Formerly, the laws of Texas favored the owner, the landlord, and the landlord usually prevailed in forcible entry and detainer cases. Changes in the law have provided the tenant with additional legal remedies against a careless or unscrupulous landlord. Unfortunately for landlords, they also have provided renters with a legal mechanism to remain in the premises sometimes for months without paying rent. Justice of the peace courts may issue peace bonds. Peace bonds are contracts enforced by court orders that prevent people from harming one another. The bond is conditioned on the promise of the person making the bond to refrain from harming another or destroying that person's property for a period of 1 year from the date of the bond. The justice of the peace sets the monetary amount of the bond, which is forfeited if the conditions of the bond are breached. A peace bond may be used, for example, to prevent two feuding neighbors from destroying each other or each other's property or committing unlawful acts intended to harass or harm the other. Appeals. Appeals from convictions of Class C misdemeanors in Justice of the Peace Court go to the county court. Since Justice of the Peace Courts, like most municipal courts, are not courts of record, trials on appeal of minor offenses in court are de novo. If the defendant is found guilty in the county court, there can be no further appeal unless the fine imposed is in the excess of $100, in which case an appeal may be taken to the Court of Appeals and, in constitutional cases, to the United States Supreme Court. Civil appeals, like criminal appeals, are heard de novo in county court. A judgment in Justice of the Peace Court that is below $20, exclusive of interest and court costs, may not be appealed except to the United States Supreme Court. Any judgment in excess of $20 may be appealed to the county court. Procedure and special functions. Criminal cases. Criminal cases in justice courts are tried under substantially the same rules of procedure as serious criminal cases in the higher trial courts. There are some variations in procedure, such as the allowance for oral pleadings and the requirements that a motion for a new trial may be made within 1 day of the rendition of judgment. Like judges, justices, under their authority as magistrates, give warnings, validate search and arrest warrants, and set bail. Another unique function of the Justice of the Peace is the conduct of examining trials. An examination trial is a court hearing to examine the sufficiency of a felony accusation made by the state. The state does not have to prove the defendant guilty of the offense beyond a reasonable doubt to prevail in an examining trial. The prosecution needs only to establish that there is sufficient evidence to bind the defendant over to the grand jury for consideration of an indictment. Since discovery is more limited in criminal cases than it is in civil cases, the defense often uses the examining trial to discover as much of the state's case as possible. Civil procedure. Civil procedure. Justice courts generally follow the rules of civil procedure that govern county and district courts. One exception is that the pleadings in Justice of the Peace Courts, except when the cause is appealed to the county court, can be made orally. A jury of 6 instead of 12 persons sits in the justice courts to determine decisions in both civil and criminal cases. Of course, this is not a jury by law. But according to this procedure, it takes a unanimous verdict to make a guilty finding in a criminal case, and 5 out of 6 jurors must be in agreement to render a decision in a civil case. Judges. Under the Texas law, justices of the peace are not required to be lawyers. Those justices of the peace who are lawyers may continue practicing while serving in this office, although justices in heavily populated counties are discouraged from practicing law. Justices of the peace are elected for 4-year terms by the voters of the precinct where they preside. In a civil case, if the justice of the peace is disqualified or absent from the precinct, parties to a lawsuit may agree to a substitute justice of the peace. If the parties fail to agree on a substitute, the county judge may appoint a qualified substitute. A justice of the peace performs a number of functions in addition to his or her primary role of presiding over the trial of cases. Each justice of the peace is a notary public and has additional power to administer oaths and to attest to the legitimacy of signatures on legal documents. Like all Texas judges, a justice of the peace has the power to perform marriages and, where there is no county medical examiner, to act as coroner. In his or her role as a coroner, a justice of the peace may be called upon to inquire into the details of any death that occurs under suspicious circumstances within the precinct. Justices of the peace may issue subpoenas and subpoenas duces tecum to require that vital witnesses and evidence be brought before them. A subpoena is a legal document that requires a witness to appear in court. A subpoena duces tecum commands a witness who has pertinent documents or other physical evidence to produce it at trial. Justice of the peace courts may issue writs of attachment, garnishment, and sequestration to gain physical control of property involved in cases before the court. Justices of the peace, as well as municipal judges, have no equitable powers and cannot issue injunctions. They do, however, have authority to consider equitable factors in arriving at just verdicts. Supporting personnel and agencies. Many of the same personnel and agencies that support the municipal courts also serve the justice of the peace courts. Each justice has a clerk who assists with the docketing of cases and keeps court records. A prosecutor presents the state of Texas in all criminal cases. The prosecutor in a justice court is a member of the office of the district attorney or the county attorney. County attorneys are elected officials who prosecute cases in the justice and county courts in counties that do not have a full-time district attorney. Police officers of the various municipalities within the particular justice precinct are witnesses in many trials of minor criminal offenses. The Texas Department of Public Safety provides law enforcement officers to testify in cases that involve offenses committed in the unincorporated areas of the county. Sheriff's deputies can also testify in these cases. Two of the most important officers who assist the justice courts are the sheriff and the constable. The constable. The constable is a peace officer elected for a 4-year term. A constable serves in the same precinct as the justice of the peace court that he or she assists. Constables may appoint deputies by making written application to the county commissioner's court. Constables serve as bailiffs in the justice of the peace court, having jurisdiction over the precinct where they are elected. Constables spend a considerable amount of their time serving civil citations, warrants, and other legal processes. A constable is not limited to civil citations issued by a justice court. Constables, along with deputy sheriffs, execute the majority of citations issued from all the trial courts and may even serve citations or warrants outside the boundaries of the precinct, but within the county. Both the constable and the constable's deputies are peace officers charged with preserving the peace by using all lawful means within their disposal. This authority includes making arrests both with and without warrants. The ones without warrants are when they are involved in a crime in the process of occurring. Sheriff. The sheriff is a law enforcement officer elected for a term of 4 years with a greater responsibility than the constable. Elected by the voters of the county where he or she presides, the sheriff is responsible for law enforcement throughout the county. A sheriff may be suspended or removed from office by the district court for incompetency, official misconduct, or intoxication. Vacancies in the office are filled by the county commissioner's court until the next general election. Deputies may be appointed by the sheriff without the concurrence of the county commissioner's court. Where county budgets are tight, a sheriff or constable may appoint reserve deputies who serve without pay on a part-time basis. Sheriffs, like constables, execute both criminal and civil process. The sheriff also authorizes deputies to serve as bailiffs in the county and district courts. As peace officers, sheriffs and their deputies can make arrests both with and without warrants under certain conditions. The major trial courts, county courts, function and history. Although county courts were originally established by the Texas Constitution of 1836, their jurisdiction was not clearly defined until the enactment of the Constitution of 1866. After the Reconstruction period following the Civil War, the jurisdiction of county courts was expanded until it approximated its present limits. Today, there are two basic kinds of courts in Texas. The Texas Constitution requires that each county have a county court. A county court that is mandated by the Constitution is called a constitutional county court and is truly supposed to function according to the common law. Additionally, county courts have been established by special enactment of the Texas legislature and are called either statutory county courts or county courts at law. The statutory court is not a real court, but the county court is supposed to be the true court under common law. These courts have been established to ease the burden of the constitutional county courts in heavily populated counties. County courts are primarily trial courts, but also have limited appellate jurisdiction. These courts and the district courts are the forum for trials of the most serious civil and criminal cases within the Texas judicial system. Criminal jurisdiction. County courts have jurisdiction over all misdemeanors that are not within the exclusive original jurisdiction of either the justice of the peace or the municipal courts. The jurisdiction extends to Class A and Class B misdemeanors. A Class A misdemeanor, as defined by the Texas Penal Code, is an offense for which the maximum punishment is confinement in the county jail for a period not to exceed 1 year, or a fine not in excess of $3,000, or both. Examples of Class A misdemeanors are public lewdness, certain types of assault, criminal non-support of a dependent, theft between $20 and $200, and burglary of a coin-operated machine. A person convicted of Class B misdemeanor can be confined in the county jail up to 180 days or fined an amount not to exceed $1,500, or both. Some examples of Class B misdemeanors are theft of more than $5 but less than $20, certain types of criminal mischief, and making a false report to a peace officer. Unless the constitutional county court is specifically granted criminal jurisdiction by statute, the court may lose its criminal jurisdiction where there is a criminal district court in the same county. In the metropolitan counties of the state, criminal jurisdiction is often transferred from the constitutional county courts to a statutory county court. Of course, this is completely out of order when it comes to the common law. All appeals from criminal convictions in county courts go to the Court of Criminal Appeals. The Texas Speedy Trial Act requires that a defendant be brought to trial quickly. The statute requires a person accused of a Class A misdemeanor to be brought to trial within 90 days of the commencement of a criminal action. The prosecution must bring a person accused of a Class B misdemeanor to trial within 60 days of the commencement of the criminal action. Failure of the prosecution to bring the case to trial within these time periods can result in the dismissal of the charges. Civil jurisdiction. County courts have concurrent civil jurisdiction with the justice of the peace courts, where the amount in controversy exceeds $200, but does not exceed $5,000 exclusive of interest. Constitutional county courts have concurrent civil jurisdiction with the district courts, where the amount in controversy exceeds $500, but does not exceed $5,000 exclusive of interest. County courts at law have concurrent civil jurisdiction with district courts, where the amount in controversy is at least $500 exclusive of interest. Neither type of county court has jurisdiction over suits involving slander or defamation of character, the recovery of land, the enforcement of liens upon real property, as cheats, divorce, forfeiture of the charter of a corporation, or suits involving execution, sequestration, or attachment on personal property valued at more than $500. County courts are also prohibited from making adjudications about a child, with the exception that they may, in certain circumstances, hear matters involving truancy under the Education Code. Although the Texas Constitution does not grant the county court jurisdiction over condemnation proceedings, this jurisdiction has been granted by statute. Condemnation, which is sometimes called the power of eminent domain, is the right of a governmental body or a public utility to take privately owned real estate for public use by paying a reasonable compensation for the condemned property. The county judge appoints 3 disinterested landowners, usually experts familiar with property values in the area where the property is located, as condemnation commissioners. The commissioners sit to hear the evidence concerning the fair value of the property. After hearing all the evidence, the commissioners make a monetary award they believe represents the fair value of the property. If a party objects to the commissioner's award, the question of fair value is tried before the county judge or a jury. Appellate jurisdiction. County courts have appellate jurisdiction over criminal and civil appeals from judgment rendered in justice and municipal courts. Appeal to the courts are usually de novo. All final convictions of Class C misdemeanors rendered in the justice and municipal courts may be appealed to the county court. Densely populated counties, such as Dallas County, have special county criminal courts of appeal, whose jurisdiction is limited to hearing de novo criminal appeals, to deal with the great volume of appeals from these lower trial courts. If the defendant is found guilty in the de novo trial, there can be no further appeal unless the amount of the fine is in excess of $100. Exclusive of court costs, the sole issue on appeal is the constitutionality of the statute or ordinance on which the criminal conviction is based. County courts have also jurisdiction of civil appeals from justice courts. These appeals would also be heard by de novo trial in county court. Civil appeals from a judgment in county court where the amount in controversy or judgment exceeds $100, exclusive of interest and costs, would go to a court of appeals. Specialized county courts. The phrase specialized county courts refers to county courts that concentrate on one or more areas of the law, such as probate and mental illness, rather than exercising the general jurisdiction granted to them by the Constitution. We have already seen one example of this in the limited jurisdiction of county courts of criminal appeals. It is often desirable, especially in heavily populated counties, to designate county judges who specialize in a particular area of the law. By specializing, these judges are better able than judges in courts of general jurisdiction to efficiently dispose of large volumes of similar cases and to render judgments that are more consistent from case to case. Where jurisdiction of more complex legal matters may be transferred from a constitutional county court, the availability of a specialized county court provides an alternative to transferring the case to district court. Probate refers to the judicial process of interpreting wills, processing estates, and appointing guardians and administrators of estates. A probate court exercises jurisdiction over the appointment of guardians for minors and the mentally incompetent. The main function of a probate court is to preside over the settlement of estates and the division and orderly disposition of property of those estates. Where there is no statutory county court exercising probate jurisdiction, some but not all probate matters may be heard by the judge of the constitutional county court. The county judge retains the right to transfer contested probate matters to the district court. Only a county court at law, a statutory probate court, or a district court may hear contested cases involving wills or guardianships. A contested case that commences in a constitutional county court must be transferred to a statutory probate court or district court. Conversely, a statutory court may, on the motion of a party or on the court's own motion, transfer a contested case to a statutory probate court or district court. A statutory probate court or a constitutional county court that hears probate matters has jurisdiction over mental illness matters. including involuntary commitment to a mental health facility. Some more heavily populated counties have mental health courts that hear these matters exclusively. Heavily populated counties such as Dallas County or Harris County further split up the county court's jurisdiction by designating certain courts as county criminal and county civil courts at law. A county criminal court at law handles nothing but criminal cases, while the county civil courts at law handle only civil cases. Therefore, constitutional county courts in more densely populated counties have few judicial functions, and these judges spend most of their time presiding over the county commissioner's court, which is the governing body of the county. This is in sharp contrast to sparsely populated counties with only a constitutional county court, which has all the jurisdiction previously mentioned. Judges. Both statutory and constitutional county court judges are elected for 4-year terms by the qualified voters of the county where they preside. Constitutional county court judges are not required to be lawyers, but are required to be well informed in the law. County courts are the lowest courts that have equitable powers. A county judge may grant relief both in law and in equity, often utilizing his or her equitable powers where strict application of the law would not serve the best interest of justice. Two equitable remedies that a county judge can grant are injunctions and writs of mandamus. Both of these remedies are granted when a remedy at law, such as a judgment for damages, would not be adequate to redress the wrong. An injunction is usually issued to prevent an act from taking place or to require a party to refrain from continuing a course of conduct that is damaging the moving party. A writ of mandamus is an order to a public official to take certain action required of him or her under the law or to refrain from certain unlawful action. For example, a sheriff who allows bail bond persons to write bonds without the required security would be subject to writ of mandamus from the county judge, requiring the sheriff to refuse to accept any more bonds from these bond persons. The same would be the case when the sheriff would be harassing one of the people of the county unlawfully. County judges may issue other writs within statutory limits that are necessary to preserve the jurisdiction of their courts. Writs of sequestration, attachment, and garnishment are issued to gain control over property that is or may be the subject of judgment of the county court. Writs of certiorari are sometimes issued to remove a case from justice to county court. County judges also have the authority to appoint counsel for indigents. The county judge also performs a number of non-judicial or quasi-judicial functions. As previously indicated, the constitutional county judge is the head of county government and presides over the county commissioner's court, the actual official governing body of the county. County judges also preside over official functions, approve applications for beer licenses, grant waivers, removing disabilities that prevent marriage, and perform marriages. The professional conduct of judges in Texas is governed by the Code of Judicial Conduct, comprising 8 canons. The first 6 canons deal with judicial behavior, titled as follows. Canon 1. A judge should uphold the integrity and independence of the judiciary. Canon 2. A judge should avoid impropriety and the appearance of impropriety in all activities. Canon 3. A judge should perform the duties of office impartially and diligently. Canon 4. A judge may conduct the judge's extrajudicial activities to minimize the risk of conflict with judicial obligations. Canon 5. A judge should refrain from inappropriate political activity. Canon 6. A judge shall comply with the Code of Judicial Conduct. Canon 7 declares that a person to whom the Code of Judicial Conduct applies should arrange his or her affairs as soon as reasonably possible to comply with it, while Canon 8 describes how the Code of Judicial Conduct should be construed and defines terms used in the Code. For a complete copy of the Code, you may go to www.courts.state.us/judethics/canons.asp. District Courts. Jurisdiction. District courts are the chief trial courts within the Texas judicial system. The most serious civil and criminal cases are tried in these courts. Unlike the justice courts, which saw their jurisdiction narrowed by consequent constitutions, the district court had their jurisdiction continuously expanded by constitutional enactments. These courts have a broad constitutional grant of jurisdiction over both civil and criminal cases. In fact, all claims are presumed to fall within the jurisdiction of the district courts unless the legislature or Congress have provided that they must be heard elsewhere. Dubai Petroleum Company versus Kazi, 12th volume of the Southwest Reporter, 3rd edition, page 71, Texas, 2000. Due to the increased caseload, some legal scholars and court administrators have suggested that the monetary amount of the court's jurisdiction be increased from the minimum of $500. This would relieve the courts of some of the less important civil cases. Geographical jurisdiction. The Texas Constitution divides the state into a number of geographical regions. These regions are called judicial districts. Each judicial district contains a district court whose jurisdiction encompasses the entire district. Densely populated counties may contain several district courts. In 1990, the Dallas County and Harris County each had more than 30 district courts. There is, however, no constitutional requirement, as in the case of county courts, that there be a district court for each county. In fact, there are a number of districts in sparsely populated areas of the state that span several counties. A single district may serve several counties, with the district judge holding court in different county seats at various times during the month. Likewise, a district court may be presided over by a judge from another district. This practice of one judge traveling from one place to the other to hold court is often referred to as riding the circuit. Since we have come to the third level of the courts in the state of Texas, we will quickly describe the levels of the district court structure in Texas. The first level, of course, we call the local trial courts of limited jurisdiction. Here you have the municipal courts and the justice of peace courts. The municipal courts have the limited criminal jurisdiction. They're usually involved with the municipal or city court. And the justice of peace courts, you have the small claims court, limited civil and criminal jurisdiction, which is in the county precinct. There are approximately 254 counties, and all judges are elected except municipal judges. The second level of Texas courts is the county trial courts of limited jurisdiction. These are the trial de novo courts. There are 254 counties in Texas. Then you have the county level courts. You have the constitutional county courts. They have the limited civil and criminal jurisdiction, and there is one in each county. You have the county courts at law, which have limited civil and or criminal jurisdiction in large cities mostly. Then you have the statutory probate courts, limited to probate matters. Such is involved with the justice of peace courts and even the appellate jurisdictions. On the third level, you have the state trial courts of general and special jurisdiction, the courts of record. And you have the United States district courts, when you have judicial districts, the trial courts of general, civil, and criminal jurisdiction. Some courts specialize by subject matter. On the fourth level, you have state intermediate appellate courts. You have the Court of Appeals with intermediate appellate jurisdiction. There are approximately 14 courts in 14 districts. Then the civil appeals and the criminal appeals can be made to the highest state courts or appellate courts, the Supreme Court or the Court of Criminal Appeals. The Supreme Court is civil jurisdiction only. It has 9 justices and 1 chief justice. The Court of Criminal Appeals is for criminal jurisdiction only and also has 9 judges and 1 presiding judge. Let us continue with the district courts. As we spoke of jurisdiction, we now consider criminal jurisdiction. District courts have jurisdiction over the most serious criminal cases. This jurisdiction extends to all felony cases and misdemeanors involving official misconduct. A felony may be defined as a serious criminal offense that carries with it punishment that may include the death penalty or confinement in a penal institution administered by a county or the Texas Department of Corrections. Some examples of felonies are kidnapping, rape, robbery, burglary, murder, arson, assault, and forgery. Misdemeanors involving official misconduct are tried in the district courts. Trials for the removal of justice, municipal, and county judges for abuse of their respective offices are all under this category of the criminal jurisdiction of the district court. Examples of official misconduct misdemeanors include a peace officer or a police officer overstepping their positions of authority. Civil jurisdiction. District courts have original and exclusive jurisdiction over all suits in which the state seeks to recover penalties, forfeitures, and cheats. All suits involving disputes over title to land, slander and defamation of character, suits involving contested elections, and suits regarding levies on personal property where the amount in controversy exceeds $500. Jurisdiction is granted to the district courts in these cases regardless of monetary amount. District courts are also granted jurisdiction over any civil matter where the amount in controversy is in excess of $500, exclusive of court costs and interest. This means that district courts exercise concurrent jurisdiction with constitutional county courts where the amount in controversy is between $500 and $5,000, and concurrent jurisdiction with the statutory county courts where the amount in controversy is between $500 and $100,000 or higher depending on the county. As explained earlier in the section on county courts, district courts have the general jurisdiction of a probate court. Only where there is no statutory county exercising probate jurisdiction, where the constitutional county court judge requests transfer or where transfer is mandatory, does the district court actually exercise probate jurisdiction. Other jurisdictional matters. As with other trial courts, judicial power vested in district courts to hear and decide issues of fact, decide questions of law, and enter and enforce judgments cannot be delegated to another court. Tabor versus Hogan, 955 Southwest Reporter, 2nd, 894. Texas Appellate, Amarillo, 1997. This means, among other conclusions, the Texas courts do not have the power to issue advisory opinions because advisory opinions are a function of the executive branch, not the judicial. Mayhew versus Town of Sunnyvale, 964 of the Southwest Reporter, 2nd, 922, Texas, 1998. The question of jurisdiction is a legal issue. Alaniz versus Hoyt, 105 West 3rd, 330, Texas Appellate Corpus Christi, 2003. When a court lacks jurisdiction, any judicial action it takes is void. Fluland versus State, 104 Southwest 3rd, 152, Texas Appellate, Texarkana, 2003. The exception is its ability to determine whether or not it has jurisdiction and, if not, to dismiss the case. Lipsky Motor Cars versus Sovereign Associates, 944 Southwest 2nd, 68 Texas Appellate, Dallas, 1997. Procedure. Criminal trials in district court are generally subject to the same rules of procedure as criminal trials in county, municipal, and justice courts. A finding of guilty by a jury must be unanimous. There are, however, some differences between criminal trials in district court and criminal trials in the lower courts. Felony trials in the district court are initiated by indictment of the grand jury. Criminal courts in the lower courts proceed on written complaints or informations that do not have to be approved by an independent body like the grand jury. Of course, this is not the case with the common law. Criminal trials in district court and county courts are bifurcated in the sense that the judge or the jury first determines the guilt of the accused and then, in a separate proceedings, sets the punishment. Criminal trials in the justice courts determine guilt and punishment in one proceeding. Finally, capital cases require the submission of special issues, all of which must be answered in the affirmative prior to the imposition of the death penalty. The Speedy Trial Act requires the state to bring the defendant accused of a felony to trial within 180 days of the commencement of a criminal action. Civil procedure. Civil trials in district court follow the general rules set forth for civil procedure in the justice and county courts. One of the primary differences, however, is that district courts use 12-people juries as opposed to a 6-people jury in the lower courts. In district courts, a verdict in a civil case must be agreed upon by at least 10 of the 12 jurors, the same proportion as in the lower courts, where 5 out of 6 jurors must agree. Since district courts are courts of record, most pleadings are presented in writing. Motions are either submitted in writing or dictated into record. Appellate review. District courts are primarily trial courts, but the Texas Constitution grants the district court's appellate jurisdiction over probate cases originating in county courts and the authority to review actions of the county commissioner's court. Since the enactment of the probate court, however, original jurisdiction of probate matters may be transferred from the county to the district court. Appellate reviews of all final orders of any court exercising original probate jurisdiction takes place in the Court of Appeals, not in the district court. Specialized district courts. Similar to specialized county courts, specialized district courts have been created in densely populated urban areas. Although each of the district courts within the judicial district has the jurisdiction to try any type of civil or criminal case within that district, in some counties, jurisdiction is limited to certain types of cases. In Dallas County, for instance, the courts are divided into criminal district courts and civil district courts. Likewise, the civil district courts are further divided into courts of general civil jurisdiction, family district courts, and juvenile courts. District courts have exclusive original jurisdiction over divorce and domestic relations matters. Family district courts are given primary responsibility for cases involving family law matters. These include, but are not limited to, adoptions and birth records, divorce and marriage annulment, child welfare and child custody, support and reciprocal support, dependency, neglect, and delinquency, parent-child relationships, husband-wife relationships. The legislature did not create different qualifications for judges of family district courts. In less populated areas, family law cases are heard by the district courts. Certain counties, such as Dallas County, have provided associate judges to assist the family court judge with overcrowded dockets. An associate judge is an attorney licensed to practice law in Texas who is appointed by the court, in this case by the family court, subject to the approval of the county commissioner's court. The family court judge may refer to the associate judge in a case involving certain preliminary motions, such as motions for temporary orders and certain pretrial matters. The findings of the associate judge are referred to the family court judge, who may approve them, alter them, or reject the findings and make new ones. The associate judge plays an important role in handling family matters not requiring a trial, so the regular judge of the family district court may devote more time to trials and other matters. Historically, juvenile law has created special problems for our system of justice. Each state has drawn an arbitrary age line below which no person, regardless of his or her experience or mental facilities, can be found guilty of a criminal offense. Texas law provides that no person under 15 years of age may be prosecuted for a criminal offense except for traffic violations, violations of certain special criminal statutes, and aggravated perjury where the offender understands the oath. Persons of age 16 are also immune from criminal prosecution unless they are certified as adults. The group of 10 through 16-year-olds is designated as juvenile and is subject to proceedings under juvenile law. Texas law establishes a juvenile court in each county. Counties having a juvenile board designate either the county or the district court as the juvenile court. In other counties, the district judge and county judges make this designation. Densely populated counties, such as Dallas County, have turned the juvenile proceedings over to special juvenile courts. A court having jurisdiction over juvenile cases presides over hearings and determines whether a child should be judged delinquent. Delinquent conduct is conduct other than traffic offense that violates a penal law punishable by imprisonment or confinement in jail, or violates a reasonable and lawful order of a juvenile court. After a child is adjudicated a delinquent, a disposition hearing is held to determine the sentence. The purpose of a sentence in a delinquency matter is to rehabilitate and protect the child. Sentences range from probation to commitment to the Texas Youth Commission to transfer to the Texas Department of Criminal Justice in especially egregious cases. Texas Family Code, Section 59.003. Children declared wards of the court are often placed in foster homes or special facilities that can provide for their physical, educational, and financial needs. A juvenile proceeding, although having many of the same elements of a criminal proceeding, is considered a civil proceeding. District Court Judges. Unlike the judges of certain lower trial courts, a candidate for judge of district court must be at least 25 years of age, a practicing attorney or a judge of a Texas court for at least 4 years, and a resident of the district in which he or she is elected for 2 years prior to his or her election. Each judge is elected for a 4-year term by the qualified voters of the district in which he or she presides. District court judges have the authority to issue writs of attachment, sequestration, and garnishment to assist control over property that is the subject of the district court's jurisdiction. Like county courts, district courts have equitable powers and can issue equitable writs to enforce their jurisdiction, such as writs of mandamus and injunction. District judges exercise authority over a number of public officials, legislative bodies, and employees. Any vacancy in the office of the district clerk is filled by the district judge. The district judge has certain appellate jurisdiction and supervisory control over the county commissioner's court. Under this power, the district court may require the commissioner's court to take affirmative action where that action is required by law. In heavily populated counties such as Baxter, Dallas, Harris, and Tarrant counties, district judges have established court coordinator systems. The duties of the court coordinators are prescribed by the district judge. Coordinators are generally hired to promote uniform and efficient administration of justice. Coordinators serve by appointment of the district judges who also determine their compensation. District judges may also hold court for any other district judge. When one district judge's caseload becomes overcrowded, or when the judge is disqualified or otherwise indisposed, he or she may invite a judge from another district to sit in for him or her. Such exchanges should be made in the best interest of justice. Supporting personnel. Both county and district courts have clerks who handle the administrative paperwork of the court and help with the docketing and processing of cases. Clerks for these major trial courts are supported by the county clerk's office or the district clerk's office. Deputy sheriffs serve as bailiffs in the district county courts by serving papers in process, keeping order in the court, and protecting the judge and witnesses. Police officers, deputy sheriffs, and other law enforcement officials and public servants serve as witnesses in district and county criminal courts. Prosecutors are provided by the district attorney's office, but in counties that have no full-time district attorney, the county attorney prosecutes cases in the county and justice courts. Since both district and county courts are courts of record, the district judge appoints court reporters to take down testimony in the court. Court reporters usually use a special typewriter called a stenotype to record testimony. The county clerk is elected by the people and provides the support in the county court. The county clerk is empowered to appoint one or more deputy clerks who perform acts that the county clerk may perform or assign to them. The county clerk is the custodian of the records, books, papers, and proceedings of the county courts. He or she must keep records of all proceedings and enter all judgments. All records and filed papers must be open for inspection, examination, and copying at reasonable times. The district clerk is likewise elected by the people and performs the same duties in the district courts as the county clerk does in the county courts. Appellate courts. Although the county and district courts have some appellate jurisdiction, they do not exercise general appellate jurisdiction and do not handle the more significant appeals. Instead, the Texas Constitution has created a series of courts that specialize in hearing appeals. Appeals in civil cases. Civil cases where the amount in controversy exceeds $100 can be appealed. An exception is the judgment of a county court or county court of law on the appeal of a judgment from the small claims court, which cannot be appealed. Davis versus Culvert, 983 Southwest 2nd 301, Texas Appellate, Houston 1st District, 1998. And review dismissed WOJ, April 29, 1999. In civil cases, when the amount in controversy in the lower court exceeds $100, an appeal may be taken to the Court of Appeals for the Supreme Judicial District where the lower court sits. There are 14 districts. Courts of Appeals are located in Houston, Fort Worth, Austin, San Antonio, Dallas, Texarkana, Amarillo, El Paso, Beaumont, Waco, Eastland, Tyler, and Corpus Christi, with 2 courts in Houston. Each court is composed of a Chief Justice and 2 to 12 Associate Justices. Each appeal is heard by a panel of 3 justices. Each justice is elected by the voters of his or her district and must be at least 35 years of age, a resident of the district, and a practicing lawyer with at least 10 years' experience. A court of appeals acquires jurisdiction of a case when a cost bond for appeal is filed in the lower court. This bond is $1,000 unless the court fixes a different amount. The bond ensures that the party taking the appeal, the appellant, will prosecute that appeal and will pay all the costs that have accrued in the trial court together with the cost of the appellate record. A party who is unable to pay the cost of appeal may file an affidavit so stating, together with a notice of appeal in lieu of a cost bond. The cost bond is to be filed with the clerk of the trial court within 30 days after the judgment is signed, or, if a timely motion for a new trial was filed, within 90 days after the judgment is signed. The filing of an appeal does not suspend the effectiveness of a trial court judgment. Unless steps are taken, the prevailing party in the trial court can enforce the judgment by demanding payment, initiating proceedings to seize property to pay the judgment, or requiring compliance with an injunction. If the appealing party wishes to suspend the effectiveness of the judgment, it must file a supersedeas bond, or cash deposit. The bond or deposit must be in the amount of the judgment plus interest and cost, or, where the judgment does not involve a specified amount of money, in any amount to be set by the trial court. The supersedeas bond ensures that the appealing party will pay the judgment and cost if it loses the appeal. After the cost bond is filed, the appellate record must be filed with the Court of Appeals within 60 days, or, if a timely motion for a new trial has been filed, within 120 days after the judgment is signed. The record on appeal consists of the clerk's record, formerly called the transcript, which is the pleadings and orders filed in the trial court, and the reporter's record, formerly called the statement of facts, which is the court's reporter's transcription of the question and answer testimony at trial. After the record has been filed, the next event in the appellate process is the filing of briefs by the parties. The appellant brief is due within 30 days of the filing of the record, and the brief of the opposing party, the appellee, is due within 25 days of the filing of the appellant's brief. Extensions or accelerations of time may be obtained if a reasonable explanation is given. The appellant's brief must contain at least 6 elements. Those elements are the names of all the parties, a subject index, a factual statement of the case, a statement of the legal points, that is, points and authorities, upon which the appeal is based, a legal argument in support of each of these points, and a statement of the relief the appellant is requesting. The appellee's brief should contain a response to these arguments point by point. After the briefs have been filed, the court schedules the case for oral argument. At the oral argument, each counsel in turn presents his or her client's legal position and responds to questions about the case from the judges. As soon as possible after the oral argument, the court will announce its judgment and will issue a written opinion setting forth the reasons for the court's decision. A party who is dissatisfied with the court's ruling may file a motion for rehearing, stating the reasons why the party believes that the court has ruled incorrectly and asking the court to change its decision. The courts of appeal also have original jurisdiction of certain types of cases and may grant writs of mandamus against lower court judges, issue writs of habeas corpus for persons imprisoned by order of a lower court, and punish any person for contempt. As with most courts, caseloads are increasing in the courts of appeals, and due to a recent amendment to Rule 47 of the Texas Rules of Appellate Procedure, requiring all civil opinions to be made public, except those involving parental notification of abortion matters, the do not publish designation in civil cases were abolished. The average time from filing a case to disposition is 8.2 months for civil cases, 8.9 months for criminal cases. Texas employs a docket equalization program that attempts to reduce caseloads disparity among the 14 courts by transferring cases from busy dockets to less busy courts. To facilitate transferred cases, the government code was amended in 1999 to permit the Chief Justices of an appeals court to which a case was transferred to consent to hear the oral arguments via teleconferencing. Appeals in criminal cases. Until the 1980 amendment to the Texas Constitution, all appeals in criminal cases, other than de novo appeals to the county court, were handled by Texas Court of Criminal Appeals, which sits in Austin and is composed of 8 judges and 1 presiding judge, all of whom are elected for a 6-year term. Over the years, the backlog of cases awaiting decision in this court grew to the point that many defendants serving short sentences completed their imprisonment and were released before their appeals were decided. To alleviate this situation, a constitutional amendment and statute were adopted, changing the former courts of civil appeals to courts of appeals and giving them criminal jurisdiction in addition to the civil jurisdiction that they always had. Under the 1980 scheme, all criminal cases except death penalty cases, as well as all civil cases, are appealed to the courts of appeal. Death penalty cases are reviewed directly by the Court of Criminal Appeals, and that court may, in its discretion, review any other criminal case after it has been decided by a court of appeals. A criminal appeal begins by giving notice of appeal in the trial court, either orally or in writing. The notice must be filed within 30 days after sentencing if there is no motion for a new trial, or within 90 days after a motion for a new trial is overruled. The Court of Appeals may extend these time limits for good use. A notice of appeal may be withdrawn before decision of the appeal, and with the consent of the court, and the prosecution may be withdrawn even after decision. The availability of release on bail pending appeal depends upon the severity of the offense and sentence. A defendant appealing from a misdemeanor conviction is automatically entitled to release on reasonable bail. A felony defendant whose sentence does not exceed 15 years confinement is entitled to bail unless the trial court finds that there is good cause to believe that the defendant would not appear to serve the sentence when the conviction became final, or that he or she is likely to commit another offense while on bail. A defendant sentenced to more than 15 years imprisonment is not entitled to bail. If the defendant was on bail while awaiting trial after conviction, the trial court may increase or decrease the amount of bail as it deems proper. In the event that a defendant is not released on bail and escapes from confinement where the appeal is pending, the appeal will be dismissed unless the defendant voluntarily surrenders within 10 days of escaping. Escaped appellants with life sentences may continue their appeals at the court's discretion if they voluntarily surrender within 31 days. After a notice of appeal is filed, the court reporter and the trial clerk, as in civil cases, prepare a clerk's record. Once this appellate record is completed, it is presented to the trial judge for approval and is filed with the clerk of the trial court and forwarded to the clerk of the Court of Appeals. Within 30 days after the record is approved, the defendant must file an appellate brief. Within 30 days of the filing of the defendant's brief, the state files its appellate brief. Unless waived by the parties, oral argument is then heard. As soon as reasonably possible, the court then renders its opinion and judgment. As in civil cases, there are provisions for a motion for rehearing. Once a criminal case has been decided by a court of appeals, it may be reviewed in the Court of Criminal Appeals. The court itself may direct that a case be reviewed by an order granting review issued within 60 days of the Court of Appeals opinion or within 45 days after the overruling of the last motion for rehearing. Should the Court of Criminal Appeals need more time to make this decision, it may issue an order for reviewing extending this time for up to 45 more days. Alternatively, the losing party, the state or the defendant, may file with the clerk of the Court of Appeals a petition for discretionary review, more than 15 but less than 45 days after the Court of Appeals opinion, or within 30 days after the overruling of the last motion for rehearing. Within 15 days of such a petition, the record is forwarded to the Texas Court of Criminal Appeals, and within 30 days of the petition, the opposing party may file a response. If the Texas Court of Criminal Appeals then denies the petition, the decision of the Court of Appeals becomes final. Or if it grants the petition, briefs are filed, oral arguments are held, and an opinion rendered, as in the case of the original appeal, in the court below. A motion for rehearing may be filed. In a death penalty case, the appeal is heard directly by the Texas Court of Criminal Appeals, following the same procedure that is followed by a Court of Appeals in ordinary criminal appeals. The decision of the Court of Appeals and Texas Court of Criminal Appeals are not reviewable in the Texas Supreme Court, which has no criminal jurisdiction. If a federal question is involved, the losing party may seek review in the United States Supreme Court after going as far as possible in the Texas appellate system. Much of the workload of the Texas Court of Criminal Appeals involves the mandatory review of applications for post-conviction habeas corpus relief in felony cases in which the death penalty is not involved. Appeals to the Texas Supreme Court. The Constitution of the Republic of Texas vested judicial power in one Supreme Court and in such inferior courts as the legislature might establish. No substantial change was made in the Texas court system until after the Civil War, when the Constitution of 1876 vested judicial power in a variety of courts in addition to the Texas Supreme Court. An amendment to the Constitution in 1891 created Texas Court of Criminal Appeals to relieve the Texas Supreme Court of its criminal jurisdiction. The 1891 amendment also restricted the court's civil jurisdiction. The court is supreme in civil cases only. It shares its status as the court of final jurisdiction for appellate cases with the Texas Court of Criminal Appeals, which has final jurisdiction of criminal appeals. While the primary function of the Texas Supreme Court is to serve as a court of last resort for the appeal of cases, the court also has a variety of other powers and functions. Among these are the licensing and disciplining of lawyers or attorneys, the promulgation of the Texas Rule of Civil Procedure, and vast supervisory power over judges of the lower courts. These additional powers of the court will be covered in greater detail in this section. The constitutional jurisdiction of the Texas Supreme Court is clearly defined. Constitutional jurisdiction is limited to questions of law arising in civil cases, heard by the courts of appeals where 1. There is a disagreement regarding the correct decision in a case among the judges of a court of appeals regarding a material question of law. 2. One court of appeals renders a decision that conflicts with a decision of another court of appeals or with a prior decision of the Texas Supreme Court. Or 3. A decision of a court of appeals holds a state statute as unconstitutional. The Texas legislature has supplemented the Texas Supreme Court's constitutional jurisdiction by granting it jurisdiction in the following instances. 1. In any case in which the Railroad Commission is a party. 2. In any case involving state revenues. And 3. In any case where it appears that an error of substantive law has been made by a court of appeals, except where the legislature has conferred final jurisdiction on that court. The Constitution grants the legislature the power to provide an appeal directly to the Supreme Court of Texas, where the trial court has issued an order granting or denying an injunction on the grounds of the constitutionality or unconstitutionality of any statute or administrative order. Extraordinary jurisdiction and powers. Like all Texas courts, the Supreme Court has the authority to issue orders to enforce its jurisdiction. The court has specific authority to issue writs of habeas corpus, mandamus, procedendo, certiorari, and other writs that may be necessary to enforce its jurisdiction. Recalcitrant judges of the lower courts are subject to process issued by the Texas Supreme Court. For the purpose of enforcing its jurisdiction, the court may issue a variety of writs against any judge of a statutory county court, statutory probate court, or district court, a justice of a court of appeals, or any officer of the state government except the governor. The Texas Supreme Court may also hold any judge, lawyer, attorney, or other party properly before the court in contempt for disobeying its lawful orders. Any person found guilty of contempt of the court may be punished by a fine not to exceed $500 or by confinement in the county jail for not more than 6 months. Finally, the court may mandamus a public official in connection with improper proceedings involving elections or political party convictions. The Texas Supreme Court is responsible for writing the rules that govern the civil procedure in all courts of the state. Unless specifically rejected by the state legislature, these rules of civil procedure, when adopted by the court, become law. The Texas Supreme Court has considerable power to equalize the dockets of the lower courts. The court can order cases transferred from one court of appeals to another, and the Chief Justice of the Texas Supreme Court can require a district court judge to move temporarily into another administrative judicial district for this purpose. Since the mid-1990s, the Texas Supreme Court has had the authority to recommend to the legislature convening 3 years of the federal census held every 10 years any needed changes in the number or allocation of appellate courts. The court also plays an important role in the training and licensing of attorneys and in the disciplining of attorneys and judges. Although it generally differs in law school accreditation matters to the American Bar Association, the Supreme Court has the authority to approve Texas law schools. Finally, the Texas Supreme Court exercises a great deal of control over judges. Upon the recommendation of the Judicial Qualification Commission, the court can censure, retire, or remove judges of the lower courts, including judges of the Court of Criminal Appeals. Procedure. The caseload of the Texas Supreme Court falls into one of 3 categories. 1, determining whether to grant review of a Court of Appeals final judgment. 2, disposing of regular causes. And 3, disposing of writs and motions. A party's appeal of a lower court decision to the Texas Supreme Court is no guarantee that the case will be heard. A party must file a petition for review, formerly called a writ of error, asking the court to reconsider the judgment in a case due to a legal flaw in the proceeding at the trial or appeals court level. The petition generally makes specific reference to the trial record where errors purportedly occurred. The brief usually accompanies the petition, explaining in greater detail why the lower court decision was in error. Petitions and briefs must be in a form prescribed by the court. In 2003, petitions were reviewed and filed with the Texas Supreme Court, and only very few were granted. 3 justices must agree to grant a review. The court generally responds to a review by writing a formal opinion. The average number of days from the filing of a petition for review that is granted to the release of the court's opinion is 621 days. In addition to considering petitions for review and writing opinions about those that are accepted, the justices of the Supreme Court also consider petitions for writs of mandamus and habeas corpus, appeals from decisions concerning parental notification for abortion involving a minor, and other matters and motions. In the fiscal year 2003, approximately 2,700 of these various writs and motions were filed, and an equal number were disposed of in one way or the other. Composition of the court. Like the Supreme Court of the United States, the Texas Supreme Court is composed of 1 Chief Justice and 8 Associate Justices. It usually takes 5 justices to constitute a quorum, and 5 concurring justices to render a decision. In some circumstances, however, the court may sit in sections to hear argument and consider other matters. All justices of the Texas Supreme Court are elected for 6-year terms by the qualified voters of the state. The terms are staggered so that 3 justices are elected every 2 years. Any candidate for justice must be a citizen of the United States and of the state, must be at least 35 years of age, and must have been practicing as a lawyer or judge of a court of record for at least 10 years.